Good morning. My name is Becky Young. I am managing partner at Grossman Young and Hammond, an immigration law firm in the Washington, D.C. area. And we're very pleased to be with you today. This is the third in a series of immigration policy webinars that we have been presenting this year. And we're really honored to be co-sponsoring this webinar along with the Restore Democracy Initiative and the Abrahamic House. So first of all, the Abrahamic House is, I like to think of it as like the real world for religious unity. So it's the first ever national multi-faith incubator for social change. Yes, and Christina pointed out, Renew Democracy Initiative, not Restore Democracy Initiative, sorry. The Abrahamic House, it's a co-living, co-learning, and co-creating space to connect, pray, organize, and serve. The Renew Democracy Initiative is a pro-democracy organization, and I wanted to share a few of their values as a way to get us started today, because I think they're really fantastic. Some of their values include freedom of speech, equal justice, due process, a rational and humane immigration policy, a government accountable to its citizens, civil discussion of controversial political issues, and safeguarding the rights of all individuals. So that's who we are. As a matter of housekeeping, I wanted to ask you, if you do have questions during the presentation, to please use the Q&A feature in Zoom. We'll be looking at the Q&A to try to answer your questions if possible during the presentation, and also we'll save time at the end. But if you can put them in the Q&A and not the chat, that will be very helpful for us. This presentation will be recorded, so we'll send it out. We'll share it with you after the fact if you've missed anything or you need to leave early. I also want to let you know we're all lawyers, but we will not be giving you any legal advice. This is for informational purposes, so please do not rely on anything that we tell you today as legal advice. Our firm, Grossman Young and Hammond, as I said, is an immigration law firm, and we regularly advocate for our clients. So that is our biggest role as lawyers, is to represent and advocate for our clients. At this time, we also feel we have a really important role to share information and our thoughts on immigration policy. So that's what we're here today to do. Half of our practice is employment-based, so we work with employers and individuals who want to work in the United States. I manage the employment-based practice, and Counsel Ann Raleigh is here with us to talk about some employment-based issues. We also have a very robust humanitarian practice, which includes criminalization and litigation. My partner, Sandra Grossman, oversees that practice and has a subspecialty in Interpol law, which is very interesting. We're joined on that side of the practice by partner Patrick Torrell and senior counsel Dave Whitmore. I'd like to outline what we're going to be talking about today briefly. So we'll start off with some information about student and exchange visitor policies. Lots going on in that area. I just read the New York Times and the Wall Street Journal this morning, and there are developments every day, it seems, with Harvard and Columbia, et cetera. We'll also talk a little bit about travel considerations. That's one area of our practice that's really boomed since January 20th. A lot of people are thinking about international travel in ways that they haven't before and have a lot of legal questions about international travel. We'll talk about the enforcement and detention climate and any new legislation that is impacting that climate. We'll talk about free speech and political expression, humanitarian protections, including CHNB parole, and we'll talk about employment-based immigration, including H-1B changes, the gold card proposal. And then finally, I should mention that our colleague Mary Pivick, who is of counsel to our firm, had a family emergency, so will not be joining us today. She is focused on employer compliance issues, and so I will be handling the employer compliance portion of the presentation, which also is an area of huge increase in inquiries since January 20th. So let's get started. Anne, if you'll kick us off by letting us know what's going on with student and exchange visitor issues.
I would be delighted. Thank you so much. And thank you all for joining us today. As many of you have likely seen in the news, there has been a lot of coverage about academia and institutions of higher education and the intersection with immigration lately. The story really appears to begin in March and April of this year, when there was a wave of SEVIS terminations. And for those of you who may not be familiar with this term, under the umbrella of the Department of Homeland Security, of course, we have Immigration and Customs Enforcement. And under that umbrella, there's the Student and Exchange Visitor Information System. And this is where all student visitors who are going to school have all of their information stored. It's a database that enables all of the processes for international students to be able to go to school. And so ICE began, it appears, systemically terminating SEVIS records at the end of March and early April. There were in the neighborhood of 4,800 confirmed, although we anticipate that the actual number is larger. And so we understand that this was done by matching names against the FBI's database, including folks who had any kind of law enforcement interaction. So there was a stir within the higher education community as a result, because there were a lot of students who immediately were affected by these emails from SEVIS saying, you've had this termination of your record. And the understanding then, of course, for these students and their institutions is that this effectively ended their lawful status. So in April and in May, there was, of course, considerable legal pushback and court intervention. We have seen since this time that there has been a federal reversal and a pause on the policy. We understand that there is an effort to have more transparency around the SEVIS system and the way that terminations will happen going forward. But certainly a couple months ago in the higher education space, this was a situation that sort of rocked many academic communities and their students. There was a nationwide injunction in late May that barred ICE from terminating legal status based solely on these automated SEVIS terminations while the litigation was ongoing. But certainly in the whole neighborhood of student visas, this was something that at the beginning of this year has really shifted the way that institutions of higher education have been managing their international student populations. Beyond what we've seen on the ground in academia, after this happened in May, we saw some movement on the part of the State Department, coinciding with the timeline. At the end of May, there was a Department of State cable that temporarily paused scheduling of student and exchange visitor visa interviews globally. And of course, this is significant when we think about the academic calendar. School typically begins in the fall. And so when all of these student visa interviews were paused in May, it created some anxiety for students who are seeking to enter and begin school for the fall semester. The idea behind this cable was that to enhance national security, there are some procedures that the government would like to implement. And many of these expanded screening procedures have to do with requesting more information about students and their social media presence. So as a result, since June 18th, all F, M, and J visa applicants are required to set their social media profiles to public and to disclose this on a form that the State Department requires called the DS-160, which is the application where you request a visa from the State Department if you're seeking to enter as a student. So the landscape changed on the ground in March and April with these SEVIS terminations. Now we're seeing the implications abroad for when folks are outside and requesting visas to come into school. And while these are specific agencies with specific policies that are affecting students, there's also, of course, the broader implications for the community of higher education. Now we're seeing certain institutions, including Harvard, most notably, who have been targeted for decertification. So the SEVIS system to which I just referred is what allows schools to enroll their international students. And so the administration's focus on some of these institutes of higher education does have the potential to create very different looking student communities if schools are no longer able to effectively enroll and keep their international students. This, as Becky mentions, is certainly an emerging issue. You could read the news one day and have an understanding of where things are, and the following day you could learn something new that changes how things are. I think this is typical in our area of practice, but especially when thinking about, again, the academic calendar year, it will be interesting to see how things emerge even between now at the end of July and in a couple months when school is set to resume, to see how this will play out on campuses across our country. In addition to the enhanced screening for social media for students, there was also a travel ban that many of you may have heard about in June. And effective June 9th, nationals from a handful of countries are also barred from getting student visas. So this also affects the population of prospective international students that would like to come to the United States, but may not be able to access a visa that would enable them to do so. These are specific policies that are affecting the ability of institutions of higher education to continue their operations with international students. But of course, there are implications for these communities and what it means for their student populations, what it looks like to be in a class, what it means for individuals who would like to begin or continue their education here in the United States. So this, of course, will be something that we see not just this fall on college campuses, but also over time to see how this might affect enrollment and then graduation rates and folks who choose to or who are able to remain in the United States after they're finished with their academic studies. Connected with this topic is outbound immigration trends, and this is something that we're seeing more of with restrictions on student visas. It makes sense that some people may be reconsidering whether this is a feasible place to continue to be educated. So while specific data isn't completely available yet from schools, it is anticipated that we will see increased outbound students who maybe started school here and then will be focusing their education elsewhere for the completion of their degrees. When I was researching for this webinar, I was interested in how the intersection of what's happening with student visas might affect what comes next, also because of something called OPT, optional practical training. Some of you may have heard of this. This is a program that enables students in the United States to seek work It's a valuable program that allows for practical training in an area that's related to the field that the individual has pursued. And recently, the USCIS director, who was confirmed this month, Mr. Edlow, has indicated that the optional practical training program might be something that is looked at differently. And so to the extent this program may no longer be available, there could be a significant impact on not just the students who would have benefited from being able to take advantage of OPT, but also, of course, organizations that benefit from students who work for them. There's a huge economic impact. Certainly, some of the estimates suggest that it's multiple billions of dollars that could be implicated if optional practical training changes in any significant way. This not only affects the jobs of the students that would be seeking these positions, but could also affect jobs held by US workers as well. Of course, the impact on entrepreneurship, on growth of these organizations, on GDP is also affected. And so this constellation of factors certainly makes this an interesting topic to keep an eye on in the student immigration space and under the employment-based immigration atmosphere, because it has such a significant potential to reshape kind of how we see the trajectory of what has traditionally been kind of the path that many students, international students, like to take when they are finished with school here. It stands to reason that when students have different opportunities and may look other places for education and for employment, there are impacts to our competitiveness in the United States. And there's some data that suggests that between the student visa restrictions and some of the outbound immigration, it's reasonable to anticipate there could be what is colloquially referred to as brain drain. When we see talent going elsewhere, it affects the ability of our country to remain competitive, especially in STEM fields where we don't have as many US workers who are graduates here. We have a lot more international students who are involved in STEM. And so thinking about the typical pipeline for these folks to become educated here and then to contribute to jobs here in the US in that industry, certainly it will be interesting to see how hiring might change and how these organizations and businesses will respond if there is no longer the same talent pool from which to draw, based on the potential for reduced students or their inability to rely on the optional practical training program. There's also, outside of this kind of business specific implication, just the idea of the loss of education export revenue. Students bring in a very significant amount of revenue. International students contributed over $38 billion to the US economy just last year. And thinking about, it's not just tuition, it's the local university communities, it's those specific economies, it's research institutions that benefit from membership of these students. And so if enrollment drops significantly from international students, it's not just brain drain, it really does have a potential to be economically significant. And then in terms of what does education mean, that's a huge question. We're not going to explore every angle of it here, but thinking about the way that research works and innovation works and progress in some of these field works, if there are barriers for individuals to continue their research, it it could have a negative impact on the ability for significant, for example, medical or scientific research to continue in a meaningful way at some of our US institutions. So certainly there are a variety of ways in which the impact to student visas expands past just the individual student who might have trouble securing a visa, or expands past the university community that might have a reduced F1 international student base. There are ripple effects that will be interesting to track as these student and exchange visa policies continue to expand.
Thank you so much, Anne. So I think we should move on to our next topic, which is travel considerations. And maybe if we can spend about 5 minutes or a little more on that topic, that would be fantastic.
Absolutely. So travel is, as Becky mentioned, a very hot topic right now. We have seen travel trends change significantly in the first 6 months of this year. In terms of data, there has been a decline in international arrivals since a couple months ago, and this seems to be linked with some of the higher scrutiny we're seeing at borders. So when folks are entering the United States after travel abroad, clearing customs appears to be a different experience than it once was. Customs and Border Protection officers, of course, are focused on national security, and the way in which that focus looks now is a little bit different. We are seeing increased incidences of people being asked to provide information from their social media. It appears that the focus might be on learning more about what people's interests might be and whether those interests are antithetical to national security initiatives as defined by this administration. Enhanced scrutiny and border detention has been something that has caught a lot of press as well. Many of you here may have read in the news about particular instances where someone has attempted to cross a border and been experiencing a lot more questioning, or even been detained. And so certainly this has been something that has changed in the last few months as well. There is the effect, of course, of the travel ban that was mentioned earlier, but more than that, the day-to-day travel experience, even for frequent international travelers, has been that this increased focus on vetting and screening has changed just the logistics of how easy or how fast do I clear customs, and what kinds of questions am I receiving. Of course, there are some people who have been able to have international travel go in ways that it always has, but we are receiving a lot more questions, and people are certainly having different experiences in their interactions with Customs and Border Protection officers when attempting to return to the country after travel abroad. Some of the things that folks are thinking about are, how do I prepare myself for travel? Of course, if you have any specific questions for yourself, it's always great to reach out to attorneys like us who can help provide a specific analysis on how your personal history might affect the ease with which you're able to travel. But definitely something that we've seen is folks who have social media presence that might have views that are controversial in the view of this administration might have a harder time entering, or certainly can anticipate the questions at ports of entry. This raises questions about how people would like to travel with their electronic devices, and what type of data they would like to continue to store on the electronic devices that they do choose to travel with. So international travel landscape is certainly something that is changing and will maybe continue to change as some of these policies evolve as well.
Thank you, Anne. Let us move on to Patrick, who is going to talk about what's happening in his area of expertise. Patrick, please go ahead.
Thanks, Becky. So First, I just wanted to quickly address the question that was in the chat box about Ukraine, Uniting for Ukraine and TPS. So Trump issued an executive order, I believe the very first day he was inaugurated, called Securing Our Borders. And in it, it called for the termination of all, quote, categorical parole programs. That includes one that Dave's going to talk about in a little bit called the CHNV program. But it also eliminated Uniting for Ukraine. So they're no longer accepting applications, under that, and haven't been, basically since his first day in office, roughly. The TPS designation has not been terminated yet. Ukrainians, who qualify still have TPS all the way through October of 2026. The re-registration period closed in March. It's doubtful that Ukraine is going to be redesignated or extended. The trend has been really to just end TPS, and even for countries that are in incredibly dire circumstances like Afghanistan. But maybe Ukraine will be different because it is an active war. So time will tell. But the trend has been to eliminate basically all TPS programs. Okay, I'm going to talk a little bit about the One Beautiful Bill, Big Beautiful Bill Act, and that's the last time I'm going to call it that. I'll just call it OBA for short because that's a mouthful. So OBA, what AILA, the American Immigration Lawyers Association, said about this bill is that it represents the most sweeping expansion of immigration enforcement in modern U.S. history. It's going to fuel mass deportations, expand detention infrastructure, and impose devastating new financial barriers to legal immigration. So I'm going to talk about a couple of these. So first, on the money, I'll try to avoid just, for me, it's meaningless when somebody says the government allocated $100 billion to this or that, but massive amount of money to Customs and Border Protection for personnel, vehicles, facilities, and so on. The law immediately gives the Department of Homeland Security $45 billion to detain immigrant adults and families. And that's going to be available all the way through September 30th of 2029. This more than quadruples ICE's annual detention budget. So right now, on any given day, there's something like 45,000 or 50,000 immigrants that are detained by ICE. That number could well double. The law explicitly approves the use of these detention funds for family detention. The law, in fact, proactively allows for the indefinite detention of children and families, which would constitute a violation of the Flores settlement, which sets forth some basic rules governing the detention of children. So to be determined how Flores is going to interact with this new statutory language. The law immediately provides approximately $32 billion for immigration agents and operations related to enforcement and deportation. And that's going to be available all the way through September 30th of 2029. My own prediction here is that this is going to lead to, a lot of hiring. And in an era of masked ICE agents, who's going to be self-selecting to apply for these jobs and who's going to be hired? And what's that going to mean for human rights and civil rights on the streets of the United States is an open question. The bill provides two separate funds totaling over $13.5 billion for states and localities to seek reimbursement for a vast array of expenses that basically amount to the direct enforcement of federal immigration laws, including border wall construction, arrests of people suspected of immigration law violations, and so on. DOJ has been allocated several $billion expressly for criminal prosecutions in the immigration sphere. And I suspect that we're going to see prosecutions under a program that we talked about on, I believe, the second webinar that we did, this registration program that I said wasn't getting a lot of attention in the media, but that now might start to, because it's up and running. People need to be applying for it if they are required to apply under it. And by the way, the USCIS website on the registration program is relatively clear in plain language. And, there's a section there that identifies who's already registered. And there's a whole lot of people that are already registered that might not realize it. That includes, visa overstays. Anyway, that registration program, there was an executive order that said that that needed to be stood up, and that people who don't comply with it need to become priorities for enforcement. And now they have the money to enforce that. Then OBA also creates massive, hikes in filing fees. So there's going to be an asylum fee, minimum non-waivable $100 fee, and an additional annual $100 fee for every year that a person's asylum application remains pending. And we have clients who've been waiting for almost a decade in some cases. Special immigrant juvenile status, which is a humanitarian protection for children abused or neglected by one or both parents. There's now going to be a minimum fee of $250. There's a border crossing penalty, which has a minimum fee of $5,000 in addition to existing penalties for any person that's apprehended between ports of entry without authorization. And there's no exception there for people seeking asylum, even though the statute allows people to seek asylum regardless of whether they enter between ports of entry or at a port of entry. There's going to be application fees for work authorization based on pending asylum applications, parole, temporary protected status, $550 for the first application, $275 afterwards. There's going to be a parole fee, temporary protected status. The minimum non-waivable fee will be $500. The current fee is $50. There's a visa issuance fee. So if you're issued a non-immigrant visa or a short-term visa like a tourist visa, it's a $250 fee, which is supposedly going to be reimbursable if the person complies with the visa conditions and don't try to extend their stay. And then there's a whole bunch of immigration court processing fees. And I won't sort of mention all of those so as not to bore you. You can find them on the EOIR, the Immigration Court Systems website. But anyway, those are some of the most significant changes that OBA brings about. On the free speech issue.
And Patrick, before you start on free speech, I wonder if you have any updates on DACA that you would like to share. I'm not aware of any updates on DACA, but maybe you have encountered some in your area of practice. So if there's anything new on DACA, would you kindly share that?
Sure. So what's surprising to me, frankly, about DACA is that it is still alive. I would have expected the administration to end it, but they have not yet. So we're still seeing, renewal applications accepted, adjudicated, approved. That's what we have seen. We have not yet had any clients who wanted to apply for, what's called advanced parole or permission to travel abroad, which you're eligible for under the DACA program if you can establish that you're traveling for a humanitarian reason or an educational reason or an employment-related reason. But I've heard that those applications are still being adjudicated as well. So it appears that the DACA program is still functioning as it did, on January 19th, as far as I'm aware.
Thank you. And also, sorry, one other just comment, if people can please put any questions in the Q&A rather than the chat, we'd greatly appreciate it. Sorry, Patrick, please continue.
No problem. So on the free speech issue, I think one thing that people are a little bit confused by sort of what kind of speech is being targeted. And so what I would say is that in the immigration sphere, pro-Palestine speech is what has been sort of the most aggressively targeted. The last time Trump was president, there was some litigation challenging enforcement against unauthorized immigrants, people who did not have the right to reside here, and who were immigration activists. There was a guy in New York named Ravi Rugbeer, which ended up resulting in a published Second Circuit decision that he was being targeted for his activism. I've seen that there is enforcement happening against an activist who resided in a sanctuary, like in a church in the Denver area. So there may be that angle. But as far as people with lawful status who are being targeted by immigration enforcement, by ICE. It's people who have engaged in pro-Palestine speech, right? Now, we've heard also things about, rogue CBP agents, checking people's phones to see if they've said critical things about Trump and things like that. But I think those are, exceptions, not the norm. I think those are, people who are not properly following normal policy and our traditions. But as far as what speech, has been purposefully targeted, it is pro-Palestine speech. And the rationale that the administration has given is that, there's a ground of deportability if a person's continued presence has serious adverse foreign policy consequences. And they've said, we have a policy to combat anti-Semitism and allowing, the kind of pro-Palestine speech that Mahmoud Khalil, the Columbia student, was engaged in, undermines our foreign policy. And in each of these cases, and there's a couple of others that have been brought, there's been representations by the Secretary of State, by Marco Rubio, saying that this person's continued presence has adverse foreign policy consequences. And there's case law that says that those determinations are basically not really second guessed. So that's what led to Mahmoud Khalil actually being ordered deported by an immigration judge. But he's not deported. His case is on direct appeal right now in the immigration court system. But Khalil also had a case challenging his detention. He had a habeas case, which ended up getting transferred to the District of New Jersey. And he also had a challenge on First Amendment grounds to that ground of deportability that they charged him with in immigration court. And other immigrants targeted under this sort of anti-Palestine, agenda have similarly succeeded in winning release in their cases, and also decisions from federal judges finding that, imposing these draconian government consequences on these people, including, snatching them off the streets and then sending them to the deep south, within hours of their detention. It's all rather shocking that those actions violated the First Amendment. There is several, and so all of those people, one was a woman named Ozturk, another one was Mahmoud Khalil. There was another Columbia student named Mohsen Madawi. They've all been freed, but their cases are ongoing in the immigration court system, as far as I know. I could be wrong about that. I know about Khalil's case. Then the other case I was just going to talk about briefly is AAUP versus Rubio. This is like the American Association of University Professors. And this is a case that was brought by university professors and others challenging on First Amendment grounds and Fifth Amendment grounds, what they call like the ideological deportation policy. That's the term in their complaint of the Trump administration of targeting, pro-Palestinian scholars and activists. And, the First Amendment doesn't just protect, your right to speak, but it also protects your right to hear ideas. And there was just a trial that wrapped up 2 days ago in the district court in Boston. And there's, we're awaiting a ruling on it, but there's been some interesting revelations from that case. And there was actually just a day or two ago published in the New Yorker an interesting piece about that trial, if you want to look at that. Okay, last real quick, I'll talk about, or unless Becky, there's something else I need to address. I was going to jump to third country removals.
Well, and actually, if we can pause for a moment, we have a few questions. So I thought maybe we could talk about those questions. So I'm going to ask one question to you, and then there's a question for Anne about students, and then I will answer the first question, which is about medical students myself. So the question relates to a Ukrainian student who, because of the current legal posture, cannot renew work authorization and cannot receive federal benefits. And this is really not a legal question, but the individual is inquiring if we know of any resources to support Ukrainians in that situation. So I don't know if you've encountered that in your practice, but people who've basically been deprived of the ability to support themselves financially. Do you have any suggestions of this for a person in that situation?
I don't know of any resources specifically for Ukrainians. I think if they've applied for asylum, which I know many Ukrainians, have, and probably many have very legitimate claims then you can, apply for work authorization after your asylum application's been pending for 150 days. But we are seeing, people who file for asylum more than 1 year after their last arrival get summoned for their interviews at the asylum office very quickly. They're prioritizing those new cases, particularly the ones that they can deny on, for failure to comply with the 1 year filing deadline. And so, you could wind up in immigration court if you're not in lawful status, soon after applying for asylum potentially. But no, I mean, I think the Asylum Seeker Advocacy Project, if I don't know if I'm butchering their name, ASAP, they might have resources, but it might be limited to people who are applying for asylum.
Okay, well, thank you. That is helpful. I know I spoke with Sandra Grossman the other day, and she told me she'd seen some newly filed asylum cases adjudicated in as little as 3 weeks. So that's kind of stunning when we see older cases that are taking more like 8 or 9 years. But there you have it. That's what seems to be happening right now. Let's turn to the next question, which is, so first of all, there was a question about H-1B. We will address H-1B later on, so please stay tuned for that. And there's a question, Anne, about F-1 students and whether we have any concerns that students who are from the countries listed in the travel ban might have their visas revoked solely because they're from a travel ban country. Obviously, that's just a hypothetical, but do you have any thoughts on that?
Yes, it's an excellent question. Thank you for sharing it. So my thought here is that if a valid visa was issued before June 9th, which is when we saw the travel ban go into effect, unless there's an independent ineligibility situation, my expectation would be that it would remain valid. So of course, being from a travel ban country is one thing. Having a separate ground that could make your visa revocable is separate. So again, underscoring the necessity to talk to someone if you do have that concern.
Thank you, Anne. I'd like to address the question about medical researchers. So the individual said that they've seen that young medical researchers, foreign medical researchers, are having a hard time finding U.S. employers to sponsor them in this climate. Given what's going on, that is not surprising to us, and also concerning. I think medical researchers are probably people that we should be encouraging and supporting in coming to do their research in our country. So I have a few suggestions, sort of practical suggestions that I would give to someone in that situation. Really, these apply to pretty much anyone who, might be a foreign national who wants to work in the U.S. So I guess the first practical suggestion is that in my experience, many jobs are not advertised. And so if you're just applying for jobs on Indeed and, message boards, I don't know how these medical research jobs are usually offered, but networking is really critical, using LinkedIn and personal resources to network, let people know up front that you need to be sponsored. So often networking can be the most practical way to find a position that requires, well, any position, but in particular here, a position that requires sponsorship. Also, the LCA database, so employers who sponsor H-1B visas, which is the principal visa for professional workers, are required to file a labor condition attestation, an LCA, and that is public information. You can find, the Department of Labor does release information, but it's not very easily digestible. There are third-party databases that will show you all of the LCAs that have been filed. They usually have a subscription fee, but if you Google LCA database, you can find companies and you can search for medical researcher or scientist or a particular geographic area to see the names of the companies that have sponsored H-1Bs. And those would be really good companies to target in your job search, because that those are companies that are willing to offer immigration sponsorship, or at least have done so in the past. For medical researchers, targeting CAP exempt organizations like universities or nonprofit research associations would also be an important strategy. So most H-1B visas are subject to a cap or quota, but medical researchers are among a privileged group of people who can often work at CAP exempt organizations. And usually those employers are more likely to sponsor workers because they don't have to take sort of the gamble of the cap. So if these individuals are not already applying to those types of organizations, targeting those types of organizations would be a great idea. There are a few types of visas that allow for self-sponsorship or quasi-self-sponsorship. So one is the E2 visa, which is the treaty investor visa. Probably based on the fact pattern, many of these students are not going to be in a position to make a substantial investment themselves, but maybe it would be possible for a group of people, it has to be from a common country, to pool resources, to start a research project or a research organization, or maybe there's an organization that's already owned by a foreign entity that could sponsor them. So like, I don't know if Merck, I don't know who owns Merck, but let's just say Merck is a French company. So Merck might be able to sponsor other French citizens for treaty investor visas. The O1 visa, again, if we're talking about young researchers, they might not qualify. They have to be among the handful of those at the top of the field worldwide. But if someone is at that level, it doesn't technically allow for self-sponsorship, but there are ways to get an O1 visa without having an employer sponsor. The J1 Research Scholar Visa is worth looking at. It has a longer duration and a lower commitment from employers than other types of visas. And then finally, these may already be PhD scientists. I'm not clear from the question, but if they are bachelor's or master's level scientists, entering a higher level of education in the US might give them work authorization related to their studies. So those are just some practical suggestions that I would make. Patrick, thanks for your patience. If you want to continue with your next topic, please.
Of course. So I was going to talk about the issue of third country removals, which has been in the news quite a bit lately with, some people being removed to South Sudan, others being removed to Eswatini, formerly Swaziland. Anyway, what's going on here? So what's shocking is that the statute, the Immigration and Nationality Act, allows for third country removals. Okay, it's permitted. The statute is silent on what procedures must be followed prior to removal to a third country. There's a kind of scheme in place that generally requires designation of a country in removal proceedings. And if you have a fear of persecution or torture in that country, you can apply for protection from that designated country. But what happens when you get order deported and they can't remove you to your home country because your home country doesn't accept their nationals, which is the case with Cuba and Iran and a number of other countries. Or alternatively, you're order deported, but your deportation to your home country is withheld because you did convince the immigration judge or the Board of Immigration Appeals that you would be persecuted or tortured in your home country. In that case, you have this existing removal order. It just can't be effected or effectuated as to your home country, but it can be effectuated to a third country. So what process do you get? Going back a little bit, there was a directive on February 18th from ICE to basically detain and deport people who can't be deported to their home country, right? Either because the government of their country doesn't accept them or because they've been granted this type of withholding of removal or deferral of removal for people who fear persecution. After that directive, some immigrant rights groups filed a lawsuit called DVD versus DHS. DVD is the initials of one of the litigants in the case, and there are several other plaintiffs. And it's a class action. It's been certified as a class action. So the DVD case said, look, the plaintiffs in that case said, you have to give people notice of the country you're going to remove them to and a meaningful opportunity to establish that they're going to be persecuted or tortured in that country. The government, after that lawsuit was filed, published a memo. Well, they didn't publish it publicly, but it ended up getting filed in that case on March 30th. And that memo sets forth the process that is now in place for removals to third countries. And under that memo, if the government receives diplomatic assurances from the third country that they will not torture or persecute non-citizens deported from the United States to that country, then the government's position is they don't have to tell you the identity of the country they're going to deport you to. You could be on a plane and they say, guess what, you're going to Uzbekistan. If, however, the US government does not receive assurances, or they do receive assurances and the State Department finds them insufficiently credible, then you get very limited process. You'll be told the country, and you basically are not asked if you have a fear of persecution there. You have to affirmatively raise it. And if you do, then you're going to get, in a very abbreviated timeline, something like 24 hours, an interview with the USCIS officer. And if you establish to the satisfaction of that officer that you do, that it is more likely than not that you'll be persecuted or tortured in that third country, then they're supposed to reopen your case and give you a chance to win protection from deportation to that place. Otherwise, if the immigration officer concludes that you don't have a sufficiently realistic fear of being persecuted, you can be deported right then. There's no further review. So that is the landscape right now, because the DVD lawsuit, while it won protection from people that required much more robust procedures, the Supreme Court a couple of weeks ago basically stayed the injunction. In other words, they said, that injunction is not in effect right now. And what is in effect is ICE's policy from March 30th. We don't know why the Supreme Court did what it did. They didn't explain their rationale. And frankly, it's a little difficult to square, what they've done in that case with what they've done in some of the Venezuelan plane cases, where they've reaffirmed, repeatedly this term that people get notice and an opportunity to be heard before they can be deported from the United States. So I think the more likely reason the Supreme Court did what they did is not that they think you don't get process prior to a third country removal, but that they, thought that this particular type of relief that the court granted was barred under this jurisdiction stripping statute. It's technical and nerdy, and I won't get into the weeds, but I think that that's probably the reason the Supreme Court did what they did. And Justice Sotomayor, who, dissented from that decision, described that argument that the government made as the one with the most force. And she's the only person on this webinar that actually was sitting in the conference when the Supreme Court justices decided, how to rule in that case. So that's why I think that's why they did what they did. But for now, people are, it's kind of the Wild West a little bit. And if somebody gets picked up, and we've had a couple of these cases, they can be removed to a third country imminently. And the only way to potentially stop that is filing an individual petition for a writ of habeas corpus, filing basically a lawsuit in federal court saying my potential removal is illegal. There can be other ways, like potentially filing a motion to reopen with the immigration court or the Board of Immigration Appeals. But, it can be challenging to do that if you still don't know where they're going to send you. So anyway, we can talk more about that if people have specific questions, but that's, I will wrap with that and hand it back to you, Becky.
Thanks, Patrick. And we have a question that I think is a very interesting one. I'm sure Sandra would have thoughts on this, but I'm wondering, Patrick, if you or Dave do, and that's whether it's an international law question. At what point would cases of unlawful detention or indefinite detention lead to modern day international tribunals or international criminal courts? So I don't know if you practice in that area. I know Sandra probably does, but if you have any thoughts about how any of these cases, how or if or when any of these cases might end up in international tribunals or criminal courts, please let us know. And if not, we can maybe pull Sandra and see if we can share something after the fact.
Dave, if you have anything, I don't know off the top of my head. What I can say is that, we're not a party to the, I believe we're not a party to the International Criminal Court. Yeah. And as far as, the decisions of, the European Court of Human Rights or whatever, they can have persuasive value to U.S. lawmakers and judges, but that's it. And they're only persuasive if the audience actually cares about what international law has to say. We do have domestic case law governing prolonged and indefinite detention. And so if you're held in immigration detention while your immigration case is pending, if that detention becomes prolonged under the law of certain circuits, you can file a habeas petition and say, hey, my detention is illegal. I should get a bond hearing. This is for people who are held without bond hearings. And that requires pretty lengthy detention, at least north of a year. And that happens when, the case sometimes ping pongs. It goes from the immigration court to the Board of Immigration Appeals, and then there's a remand. That's when you see these long, pre-removal order detention timelines. And then you can also challenge detention after there's a final order of removal. So if you're, for example, the government used to never deport people to third countries. It was an extraordinarily rare event. And in those circumstances, if you were, say, Cuban, the Cuban government wasn't going to take you back. ICE couldn't hold you forever, right? And there's case law that says, it's presumptively permitted for them to hold you for about 6 months while they try to remove you from the United States. But beyond that, if the government can't show that your removal is significantly likely in the reasonably foreseeable future, that's the language in the case law, then you're supposed to be released.
All right. Thank you so much, Patrick. So I think it's time to move on to Dave. And Dave, if you would like to make any brief self-introduction, feel free. And otherwise, please go ahead. And there are a few questions on H-1Bs. So after Dave speaks, we'll move on to business topics. And I would like Anne to address those 2 questions, please. All right, please go ahead, Dave.
All right, thanks, Becky. Good morning, everybody. I am Dave Wetmore. I joined the firm a few months ago. Prior to that, I was the Chief Judge of the Board of Immigration Appeals. And I will go ahead and start my discussion with temporary protected status and the changes that have occurred over the last 6 months with that program. So temporary protected status, or TPS, is a temporary immigration benefit that allows foreign nationals from designated countries to live and work in the United States when it is unsafe for them to return home due to conditions like ongoing armed conflict, natural disasters, or other extraordinary and temporary conditions. TPS does not provide a pathway to citizenship, but it protects recipients from deportation and allows them to obtain employment authorization during the designated period. It applies to individuals from countries who are within the United States at the time of the TPS designation. And it sets forth in the designation when individuals would need to be present by in order to apply. During the first Trump administration, DHS moved to terminate the TPS designations for multiple countries. Litigation followed, alleging that those terminations violated the Administrative Procedures Act. That's an act that says that agencies basically must abide by the law and act within the scope of the authority that's given to them. And they were they argued that they were racially motivated. In 2018, in Ramos versus Nielsen, a district court judge issued a preliminary injunction blocking the termination of TPS for El Salvador, Haiti, Nicaragua, and Sudan. While the U.S. Court of Appeals for the Ninth Circuit reversed that decision in 2020, the first Trump administration was unable to fulfill its goal of terminating those TPS designations before the start of the Biden administration. The current Trump administration has again moved to terminate many TPS designations, which has again resulted in litigation alleging that the terminations violate the Administrative Procedures Act by disregarding country conditions and instead relying on predetermined political decisions to terminate those designations. I'll touch on a few of the countries because they kind of have different postures in terms of where the litigation has gone. First, Afghanistan. Afghanistan was initially designated for TPS on May 20th, 2022, based on ongoing armed conflict in that country. On September 25th, DHS extended and newly designated Afghanistan for a period of 18 months. When there's a new designation, that date, they get a new date by which the individuals present in the country can apply for TPS. So TPS can either be extended, and that would only be relevant for those individuals who were in the original designation. But if there's a redesignation, then it moves the date forward and includes new individuals who were present in the United States even after the previous designation. In a notice published in the Federal Register on May 13th, 2025, DHS announced that it was terminating TPS for Afghanistan effective July 14th. On Monday, the Court of Appeals for the Fourth Circuit in Casa versus Nome denied the request to postpone the termination while litigation was ongoing in the district court. The Fourth Circuit's decision also allowed the Trump administration to proceed with termination of the TPS designation for Cameroon, which is scheduled to end on August 4th. This impacts approximately 11,000 Afghans and over 5,000 Cameroonians who are in the United States and previously eligible for TPS. Next country I'd like to touch on is Haiti. Haiti was initially designated for TPS on January 21, 2010, following a devastating 7.1 magnitude earthquake in that country. Haiti was designated for TPS, and the designation was extended multiple times. In January 2018, the first Trump administration published a notice in the Federal Register terminating TPS for Haiti effective July 22, 2019. The termination was tied up in litigation for the remainder of the first Trump administration. The Biden administration redesignated and extended the designation multiple times through February 3rd, 2026. However, on February 24th of this year, DHS announced that it would reduce the designation period from the statutory maximum of 18 months to only 12 months, providing that Haitian TPS extension and new designation will now expire on August 3rd of this year. Litigation followed, and on January 15th, a judge in the U.S. District Court for the Eastern District of New York issued a final judgment in Haitian Evangelical Clergy Association versus Trump that makes the effective date of any termination no later than the original date, which was February 3rd of 2026. It remains to be seen what will happen in that litigation, which is ongoing. Next, I'd like to touch on Honduras, which was initially designated for TPS on January 5th of 1999 in the aftermath of Hurricane Mitch. DHS in 2018 announced the termination of TPS for Honduras to be effective January 5, 2020. However, in response to litigation, DHS announced on May 10, 2019, that it would not implement or enforce the decision to terminate that TPS designation. On June 21, 2023, the Biden administration published a notice in the Federal Register reconsidering and rescinding the Trump 1 termination of Honduras TPS. The rescission was effective on June 9th, 2020, and the new 18-month extension of TPS for Honduras began on January 6, 2024, and it would remain in effect through July 5th of this year. However, on July 8th of this year, DHS published a notice in the Federal Register announcing the termination of TPS for Honduras effective September 8th of this year. With the assistance of the ACLU and the National TPS Alliance and individual TPS holders, a lawsuit was filed in the U.S. District Court for the Northern District of California, alleging that the termination was based on violations of the Administrative Procedures Act. That litigation is ongoing, and it also includes a termination of the TPS designation for Nicaragua and Nepal. Speaking of Nicaragua, like Honduras, Nicaragua was designated for TPS also on January 5th, 1999, in the aftermath of Hurricane Mitch. DHS also attempted to terminate TPS during Trump 1, but it was tied up in litigation until on January 21, 2023, the Biden administration published a notice in the Federal Register rescinding the termination effective June 9th, 2023, and a new 18-month extension of TPS for Nicaragua began on January 6, 2024. And it would remain in effect through July 5th of this year. On July 8th of this year, DHS published a notice in the Federal Register announcing the termination of TPS for Honduras effective September 8th of this year. And that decision is being challenged in the district court in California. Now we have one interesting outlier in Central America, and that's El Salvador, which was originally designated for TPS on March 9th, 2001, following two separate massive earthquakes in that country. On January 18, 2019, DHS under Trump 1 announced the termination of the TPS designation for El Salvador, effective on September 9 of 2019. However, like Honduras and Nicaragua, the El Salvador TPS termination was tied up in litigation, and on June 13, 2023, the Biden administration announced the reconsideration and rescission of termination of El Salvador's TPS designation and extended it through March 9th of this year. On January 17th, 2025, the Biden administration announced an extension of the TPS designation for El Salvador through September 9 of 2026. Interestingly, that designation remains in effect, and the current administration has not moved, unlike it did last time, to rescind that designation, likely due to cooperation that El Salvador has provided in immigration enforcement, as we've seen in the news. Okay, that moves us to Venezuela. So on March 9th, 2021, the Biden administration designated Venezuela for TPS. And on September 8th, 2022, it extended the Venezuelan 2021 TPS designation for 18 months. On October 3rd, 2023, the Biden administration again extended the 2021 designation by another 18 months. However, it also issued a new and separate designation for Venezuela for TPS, resulting in two separate and concurrent TPS designations for that country. This is important because on February 5th, 2025, DHS published a notice in the Federal Register terminating only the 2023 designation of TPS for Venezuela effective April 7th of this year, and it stated that the 2021 designation will remain in effect until September 10th of this year. In May, the Supreme Court in Nome versus National TPS Alliance stayed a district court judge's order preventing the termination of the 2023 designation from going into effect while litigation was ongoing. Thus, approximately 300,000 Venezuelans in the 2023 designation no longer have TPS, even though the litigation regarding that termination continues, and they also no longer have permission to work lawfully in the United States. All right, the next topic I'd like to cover is CHNV. That's a parole program that on January 6, 2023, the Biden administration opened as a humanitarian parole program, allowing certain nationals from Cuba, Haiti, Nicaragua, and Venezuela, collectively known as CHNV, to apply to be paroled into the United States for up to 2 years. All individuals admitted through the CHNV program were required to have a US-based supporter, pass security vetting, and meet other criteria. It is important to note that parole is not an immigration status, however. During the 2-year parole period, the individuals could seek humanitarian relief, such as asylum, or other immigration benefits, and they were permitted to work during that time. The Biden administration committed to accepting 30,000 beneficiaries a month from across the 4 countries, raising the cap on a previous parole program solely for Venezuelan beneficiaries. Within the first 6 months of launching the program, over 35,000 Cubans, 50,000 Haitians, 21,000 Nicaraguans, and 48,000 Venezuelans came to the United States through that program. In total, over 500,000 people were granted parole through the CHNV parole program. On January 20th of this year, however, President Trump issued an executive order directing DHS to terminate the CHNV parole program. On March 25th of this year, DHS published a notice in the Federal Register that it was terminating the program and that any parole period that had not terminated on April 24th, 2025 would terminate on that date. Of course, litigation followed, and on May 30th of this year, the Supreme Court in Svetlana Doe versus Nome granted the government's request to stay an order issued by a district court judge in the U.S. District Court for the District of Massachusetts that did not allow DHS to implement the termination of the program during the pendency of litigation. On June 12th of this year, DHS began issuing individual notices to CHNV parolees stating that their parole is terminated and their parole-based employment authorization is revoked effective immediately. Some 500,000 former parolees are now subject to removal and no longer have work authorization in the United States. My final topic are some changes that have recently occurred over the last 6 months in the immigration court system, where I used to work. On January 20th, 2025, just hours after President Trump was sworn in, the acting attorney general summarily fired without cause all of the leadership of the Executive Office for Immigration Review, including the acting director, the general counsel, the head of the Office of Policy, chief immigration judge, and the chief appellate immigration judge, which was me. In addition to those changes, numerous other regional deputy chief immigration judges who oversee large swaths of the country for the trial level immigration court system were also terminated, as were numerous assistant chief immigration judges who oversee directly individual immigration judges. Numerous other immigration judges who were in their 2-year probationary period were also terminated. This greatly reduced the number of active judges, in particular judges who were appointed in the last 2 years by the Biden administration. On April 14th of this year, EOR, or the Executive Office for Immigration Review, published an interim final rule in the Federal Register that reduced the size of the Board of Immigration Appeals from 28 appellate immigration judges to only 15 appellate immigration judges. This effectively eliminated the positions of every appellate immigration judge appointed during the Biden administration. At one point, the Board of Immigration Appeals was down to 9 active appellate immigration judges due to subsequent retirements and resignations. In June, the Attorney General appointed 6 temporary appellate immigration judges, so the board currently has 15 active judges. Obviously, that's a lot fewer adjudicators than were on hand on January 19th of this year. And to put that into perspective, in fiscal year 24, which was my last full fiscal year running the board completed a 15-year high in case adjudications, and case adjudications, as you can see on the Executive Office for Immigration Review's website, have declined considerably. That means a lot fewer people are getting final orders of removal, because those final orders of removal only take effect if the case is appealed from the immigration judge's decision after the board would issue its decision dismissing the appeal. The profile of new immigration cases over the last 6 months has also changed dramatically with the large surge in detained cases. Detained cases are heard on an expedited basis, both by immigration judges and by the board, which is based on regulatory requirements that those cases be resolved generally within 6 months. And many immigration judges who normally hear non-detained cases are now being tasked with hearing detained cases in order to meet some of those deadlines, although it's really not clear if the board's going to be able to meet those deadlines given the surge in cases it's experiencing and the large reduction in the number of active judges. The same is true of the board's caseload in particular, because the board basically is only doing detained cases at the moment from what we understand. So if an individual has an appeal pending with the board in a non-detained case, it's likely that the time to get a decision in that case will be considerably extended. And that is really all I have. I appreciate your time.
All right.
I'll kick it back to Becky.
Thank you so much. So Anne, we had a lot to say today. And so if you could, I think maybe first address the 2 questions in the chat, that would be great. And then maybe just give us like a quick 1-minute overview on any changes to H-1B and the latest on the gold card, which I think really is, there is really nothing on the gold card. But anyway, I'll let you briefly talk about those subjects.
Thank you so much, Becky. And you're right, that spoiler pretty much covered it on the gold card. But for the H-1B, we do have a couple questions. Great questions. Thank you for contributing. One of them asks to comment on whether we expect the administration's stance on the H-1B visa category to change, considering Mr. Musk's departure from the administration. So I do think that this is a really interesting question. One of the changes that we're seeing in H-1B is a recent proposal within this last week, which is a reemergence. As many of you may know, that H-1B is a lottery system, and right now it's a largely random lottery. The proposal suggests that the shift to take place should be sort of meritocracy based. So if there is a higher salary for a position, it may receive more weight in a lottery, and that would change what types of cases are more likely to be selected. So this would not take effect until 2027. There's a lot that needs to happen between now and the time that such a lottery system would be in place. But this does sort of answer the question on whether there has been an update on H-1Bs. We expect there to be more, especially as a result of this recent proposed rule. Again, this most recently proposed rule was within the last week. So we all have a lot to learn. It will be interesting to watch it emerge. Now, as to whether we expect the administration's stance on the visa category to change, it's another great question. You know, the president himself has said that he's a proponent of this program. And certainly there is a huge economic impact. But there are some individuals, including Mr. Miller, Steve Miller, and Mr. Edlow, who have ideas that restricting certain aspects or changing the view of certain aspects of the H-1B program would be beneficial, keeping in mind that you know, there are a lot of hoops to jump through to make more significant changes. So remains to be seen is the bottom line. Now on the gold card, this is a proposal that's highly unlikely to kind of come into fruition as real law. It takes congressional authorization. It would require a whole new visa category to be implemented. And right now, in terms of legislative action and supports, there's some significant limitations. So I think we'll all look forward to seeing how this plays out in the news, but won't see it turn into law anytime too soon. So I know that we could all talk more about this, but I'd love to turn it back to Becky so that she can cover workplace enforcement trends.
I am muted. Thank you, Anne. Mary Pivick, as mentioned, is our hands-down expert in workplace enforcement, and she and our team have been very busy doing a lot of I-9 audits, both actual audits where ICE has visited employers, as well as internal proactive I-9 audits, which we will definitely recommend as a best practice. So Patrick talked about the big bill that was recently passed. And I saw a very interesting factoid, which was that the $165 billion in funding for ICE, which was allocated in that bill, exceeds the total funding for the FBI, DEA, ATF, U.S. Marshal Service, and the Bureau of Prisons combined. So that's a lot of money. And it's all going to ICE enforcement, and I think we will see the impacts soon. There are a few things that we've already seen. One is a surge in I-9 audits. So I-9 audits are sort of the first step in employer compliance. They are administrative. They start with a subpoena, and they ask employers to provide their I-9 documents. I-9s are the documents that employers are required to collect to show that their workers are authorized to work in the United States. So since about 30 some years ago, employers have been required to basically police their workforce to confirm that the workers are authorized to work in the US, which is very challenging for employers. You might have noticed that, you know, we have like our own language, our own legalese among lawyers. And so I think that for the average employer, understanding all of these legal documents and legal terms can be very challenging. There has been a 10-time increase in I-9 audits since the beginning of this year. So the number of I-9 audits has increased about tenfold. The estimate is that about 10,000 I-9 audits have happened so far this year, which means we're potentially on pace for about 20,000 audits in total. In the DMV, We saw the effects of this in the month of May when there were hundreds of raids, in particular targeting the restaurant industry. So there were over 100 raids on DC restaurants in the month of May. And we don't know what is the next step. I'm going to talk about ICE raids, which are, traditionally sort of the next enforcement item that could happen after an audit. We don't know whether they're going to be raids, but it's certainly possible that ICE is taking the data that it's gathered from these I-9 audits to plan for targeted raids. So it's certainly something that's on our mind. We also noticed there was a raid in San Diego at an Italian restaurant called Buona Forchetta. And in that raid, the complaint is very interesting because it seems to be holding employers to a higher standard than traditionally has been the case. What I learned as an immigration lawyer, and I've been practicing for about 30 years, is that employers are not required to be document experts. They're required to look at the documents an employee gives them and to see if the documents are facially valid. But in the Buona Forchetta case, at least, it seemed like ICE was holding employers to a much higher standard. So just as one example, an employee presented a green card and the green card had 2 wavy lines. But in fact, at that time in history, when green cards were issued, they had 3 wavy lines. And so there is a document called the M274. It's the employer handbook, which employers can use to give them guidance in completing I-9s. And it does have sample pictures of green cards. And so the employers generally, historically, have been asked to look at the green card if they're given one and make sure that it looks like a valid document. But now it seems that ICE may be asking employers to act more like a forensic scientist and to identify all of the small details of the green card, and they change every few years. So you would have to see when the green card was issued, compare it to the green card from the same time period in the book, and then identify all the details to see whether they're the same, which is really in my opinion, an unreasonable burden to put on employers. I think even as experienced immigration attorneys, we wouldn't necessarily be able to do that. But that's what we saw in the Buona Forchetta case. We do strongly, I can't emphasize enough, encourage all employers to conduct an internal I-9 audit. It is really important to have your I-9s in order and, so that you would be able to present them if you are audited. E-Verify is a best practice. To the extent you're able to enroll in E-Verify, that is recommended. Some changes with E-Verify, there are now enhanced notifications. So Dave talked about all the TPSs, this designation period, that designation period. This one has ended, that one hasn't. It's super confusing. Again, even as very experienced immigration lawyers, it's very hard for us to keep track of who has TPS and who doesn't. But employers are expected to do so. And so E-Verify is now sending notices about EADs, employment authorization documents, being revoked when TPS is revoked. So that's a new thing. We haven't really talked about birthright citizenship, but I think I just want to mention from an employer compliance perspective, this is all tied up in the courts. So the Supreme Court did speak about birthright citizenship, but only on a procedural issue of what's called nationwide injunctions. The Supreme Court has not gotten to the issue of birthright citizenship substantively and whether it's, it can be taken away or not. So we certainly, as employment side immigration lawyers, would dread the day when that happens, because if people are born in one state on one date, they might be a citizen. If they're born in a different state, they might not be a citizen. And then people obviously move from state to state. So it would be very, very, very challenging for employers to determine who actually is a citizen and who isn't. Not just employers, hospitals, government, et cetera. I think birthright citizenship has the potential to be very, there are many issues with revoking birthright citizenship, and this is just one of them.
Becky, just really quick, I think, yes, I haven't read the opinion yet, but I believe yesterday the Ninth Circuit declared that the executive order purporting to end birthright citizenship was unlawful and contrary to the plain text of the 14th Amendment. And I think people are trying to bring class action lawsuits challenging this, and that presumably wouldn't be impacted by the Supreme Court's new take on nationwide injunctions.
Although, Patrick, correct me if I'm wrong, I think the thing about class actions is if they only, I mean, depending on who's in the class, it could still create a situation where some people have citizenship and some people don't.
Yeah. I mean,
So
what I
that's-
can say is that I'm not aware of a single court that has deemed the executive order substantively lawful.
Yeah.
And I think as people keep bringing cases, hopefully we'll get law in different jurisdictions that recognize that.
Yes. I think probably you would agree with me that it's the executive order is not lawful, but I guess we'll see what the what the courts have to say about that. So on the topic of raids, raids involve a lot more resources, so they're a lot less common. There have been about 24 reported official raids since January. It's estimated that there are actually about twice that many, so about 40 to 50 raids have actually happened this year. Over 100,000 individuals have been arrested in the first half of the year, averaging about 750 arrests a day. So that's what's going on in employer enforcement. We have a few more questions in the Q&A. Yes, we will offer a copy of the recording after this webinar. So that I believe that will be sent out to the attendees, and it will also be available on our website, as are all our prior webinars. So as mentioned, this is the third in a series of webinars, and it's all available. I did want to mention, if anyone else has questions, feel free to add them to the Q&A. I think that Patrick, we do have a second if you want to maybe speak on denaturalization. There's a question about denaturalization. Do you have any thoughts that you'd like to share?
Yeah, so denaturalization is a procedure, established by law. There's, it has to be done through a federal district court. It's a pretty resource intensive proposition for the government. They can't do it arbitrarily. They can't do it if you engage in speech they don't like. Your citizenship has to have been unlawfully procured in some fashion, whether that's through fraud or, not necessarily fraud. There's other ways, but it's, rarely done. I think on one of these earlier webinars, I said, I think there's going to be more bark here than bite when it comes to denaturalization. But look, the fact that they did just get an influx of resources in DOJ means I think we're going to see more of this than maybe I originally thought. But I don't think this is going to be a commonplace thing. And I don't think people, should be fearful that their citizenship, if they naturalize, is going to be taken away. Unless, they were, what circumstances do you see frequently is, you lied to get your green card, you, said you'd never committed a crime for which you hadn't been arrested, but then after you naturalized, you plead guilty to a crime that occurred before you said that to immigration officials. Like that's kind of a fact pattern that we see. So I think absent something like that, I don't think people need to be, losing sleep over this possibility. But obviously, every case depends on the individual circumstances. I don't know, Dave, do you have anything to add on this?
Yeah, a couple things. When I was working for the Deputy Attorney General in the first Trump administration, I was running the immigration portfolio, and one of the priorities there were to stand up a section within the Office of Immigration Litigation that's in DOJ Civil Division. It's the group of attorneys who represent the department before the Board of Immigration Appeals, as well as in some district court litigation. I litigated there for many, many years on the appellate side before I worked for the DAG and then ultimately became the chief appellate immigration judge when AG Barr appointed me and Trump won. And what the purpose of that was, there's two types of denaturalization cases. The first are criminal denaturalizations. Those are fairly easy to prove. It's a type of scenario that Patrick touched on where a crime has been committed. It ran into the time in which you said you hadn't committed any crimes when you filed your naturalization application, your N-400, and in fact, you had been committing crimes. and they have the criminal conviction there. They use that as proof that you lied, and it's a fairly quick process. The other is civil denaturalization. It has no statute of limitations on it, and that's instances where you lied about other areas. For instance, there were a number of cases of people who were later determined to be war criminals, Nazis, some folks from Serbia, Cambodia. And once those people were discovered, they came in generally under, fictitious identities, had gone through the immigration process, naturalized, and obviously not disclosed that they were a war criminal. And those are the types of cases that we're seeing in the past, or areas where there was clear fraud, identity fraud, things of that sort, not involving war crimes. But that's the type of cases that were being brought. They stood up sort of a standalone section to dig into those types of cases. But it was, those cases were really within those categories, intentional, knowing fraud, misrepresentation, that sort of thing. It wasn't someone forgot to check a box or didn't dot an I, because those cases, it's very unlikely that they would stand up in district court. So, obviously, I think that there will be an increase in those types of cases being brought in the federal courts, and I would expect them to stand up and dedicate resources to that within the Office of Immigration Litigation. But I don't see it as something that anybody should worry about unless there's major issues that weren't disclosed when at the time of going through the immigration process, and in particular filing the N-400.
Thank you so much, Dave. So we had a lot to say. There's a lot going on in immigration, and we thank you all for joining us. There was one final question about I-9s and internal audits. I'm just going to answer very, very briefly. If you discover issues with the I-9s in an internal audit, you can correct them with a colored pen, initial and date. You never want to make changes where you're obscuring the changes. But if you do find changes, you can make them and make them very obviously. And if you do that before you get audited, you usually will get credit if they're paperwork errors and not substantive errors. If if employers have more questions about I-9s, or really if anyone has other legal issues that they would like to consult about, please go to our website. We are available. If you feel like we missed something on the webinar today, feel free to reach out to us. You can find all of us on the attorneys page of the GYH website at grossmanyoung.com. Again, thank you so much for joining us. It was our great pleasure to be with you, and we will be sharing a recording of this webinar after the fact. Have a great day. Bye-bye.